Now, I'd like to start, Ms. Ashley, by talking about immediate suspension orders, or ISOs. There have been a lot of allegations that the Ensuring Patient Access Act gutted DEA's ability to issue ISOs and caused enforcement actions to plummet. So let's look at the actual data. Is there any conceivable way that the act could have caused a decline in ISOs?
Senator, this is a tool for immediate suspension orders that DEA has historically used sparingly. Again, we move forward with where the evidence takes us. Now, they've been used sparingly, but they've also been used for the most part, predominantly for physicians and also for pharmacies. It's a difficult challenge to connect a distributor and immediate.
Yeah, but I was asking for a yes or no answer.
Has it changed?
No.
Has it impacted our ability to issue ISOs? No, sir, it has not.
In fact, you'll note that DEA issued more ISOs in 2017, the year before the act passed, than it did in 2015, the year before it passed. I'd also direct your attention to the short orange bars on the chart. These represent ISOs against distributors and manufacturers. The blue bars are total ISOs, and the orange bars are ISOs against distributors and manufacturers. ISOs against distributors and manufacturers have been a particular focus of news reports criticizing the bill. Now, these reports have described these ISOs as DEA's most effective tool against large drug companies. Now, Ms. Ashley, looking at the chart, when the Ensuring Patient Access Act passed in April 2016, how many years had it been since DEA had issued an ISO against a distributor or manufacturer?
The last one was 2012, sir.
I'm sorry, I didn't hear you.
The last one was 2012, sir.
Okay. In fact, it had been just under 3.5 years, as I see it. So not only could this law not possibly have caused a decline in ISOs, but at the same time the law passed, it had been over 3 years since DEA had issued an ISO against a distributor or manufacturer. Simply put, the notion that ISOs against distributors and manufacturers were a critical and frequently used tool before the Ensuring Patient Access Act passed, and that the act caused DEA's use of the tool to dry up, is simply not correct. Would you agree?
Oh. Yeah, I do agree, sir, but
Okay, that's all
We had these conversations with DEA when this bill was being developed, and we reached an agreement that DEA signed off on that was approved by the administrator, that was approved by the Attorney General of the United States, and on the recommendation of the Attorney General of the United States, was signed into law by the President of the United States. So forgive me for just a bit of frustration when we are now in a situation in which the executive branch, in the form of HHS, which is to be advised by you all at DEA, is under a legal obligation to do an analysis of what changes are needed in this bill and has refused to do so, despite being required to by law. And we have the testimony now of your agency that you have no proposal, despite a recommendation that there be a change. That's a little tough for us to work with. We are happy to try to do this and to try to make sure we get it right. But at the moment, the state of the record is that DEA signed off on the bill as it is. DEA has no proposal to change it, and HHS refuses to do the report that Congress commanded. That doesn't give us a great position. So I hope that in whatever way you can try to get these basic questions answered so we can proceed. Now, your testimony has been that you have a bucket of tools and that you have not been hamstrung by this piece of legislation because you have that bucket of tools. So let me take a minute and just go through that bucket of tools and make sure that I'm not missing any. One is letters of admonition. You can do letters of admonition more or less unilaterally, can you not?
Yes, sir.
And the second is you can call administrative hearings. And you can drag a distributor in to answer for their conduct, can you not?
Yes, sir, and those would be informal hearings.
Yes. And you can require a memorandum of understanding to be entered into by a registrant as a resolution of a dispute with DEA, correct?
That is correct, sir.
And you can even demand voluntary surrender of the license so that they have to just give it up and cash in and go away.
Yes, sir.
You can go to court if a registrant is recalcitrant and get an administrative law judge of yours to issue an order to show cause requiring them to defend their license, correct?
Yes, sir.
And that puts immense pressure on them, even the threat of that, to come into compliance.
Yes, sir.
And the ability to push for that order to show cause is unilateral on your part.
Yes, providing evidence, yes, sir.
Yes. And you can bring civil penalties, civil action. You
Yes,
can take DOJ lawyers and go into court against them.
Yes, sir.
And indeed, in 2017, you hit a record for $194 million in civil penalties against distributors, correct? Well, I'm not going to hold you to the number, but let's say pursuing civil penalties
Yes.
is and has been an effective enforcement technique against diversion.
Yes, sir.
Okay. And then finally, criminal actions. My information is that you make about 1,500 diversion cases a year in the criminal courts, in which you have the requisite intent to show and somebody actually is sanctioned, goes to jail, gets a criminal fine levied against them for all of that.
Yes, sir.
1,500 per year.
That's average, sir.
So if you have that kind of authority, then in the context, the last time you did an ISO of a distributor manufacturer was back in 2012, correct?
Yes, sir.
And let's just say you were hesitant in 2015, the agency, because the bill was coming up in 2016. But so let's go back 2 whole years to 2014. You only did 8 ISOs in that whole year compared to 1,500 criminal cases, correct?
Yes, sir.
So it doesn't sound like it's a centerpiece of your enforcement bucket of tools.
Sir, if I could say that most of the ISOs and also orders to show cause are on physicians and pharmacy. Historically, they've been used very sparingly on distributors and manufacturers.
And there's a pretty good reason for that, because usually distributors, let's focus on distributors, because that was the
Yes,
purpose
sir.
of this legislation. Usually distributors aren't a factor, really, in the direct diversion of pills, unless you find that they have lost control of their inventory and are slipping stuff out to the public. What they're doing, mostly in these cases, as I understand it, is failing to report to DEA where drugs are going in inexplicable numbers. I mean, how often do you see a diversion case where the opioid pills are directly leaving a distributor into the hands of the illicit user?
It doesn't, sir. But what happens is the distributor is responsible to
Correct.
exercise due diligence.
Yes. So it's a reporting and due diligence requirement, not a direct diversion issue, correct?
Yes, sir, it leads to.
Yes.
And it
It leads
increases
to it.
the potential.
Absolutely.
Yes.
On the part of the pharmacy, on the part of the doctor
Yes,
pill
sir.
mill, on the part of whatever's happening downstream where the opioid pill meets the illicit consumer.
Exactly. And
Okay.
this is where that legislation,
Great. So we look forward to,
concern.
if you have recommendations, we're eager to hear them. But I will conclude by saying it's incredibly frustrating to have the agency that signed off on this and supported it all the way through to the President of the United States, now saying that it needs a change, but it's unable to articulate what that change is. And at the same time, the parallel agency, HHS, which is under legal obligation to report to us on how this is working and what we should do, refuses to comply with the law and provide the report that we've asked for. So we will continue to make these inquiries. We really want to get this right.
thank you, sir.
And thank you for your service.
If they refuse to do it, as opposed to not having it done yet, I would be willing to follow up with you on that, because if we pass a law saying they ought to make a report, they ought to make the report.
Yeah, and the law has a date in it.
Are you,
They haven't met the date.
Are you saying they're actually never going to do the report? Is that
I
what?
have no idea. They're 8 or 10 months late right now. I don't.
Okay.
And there's no sign of it on the horizon. So
Senator-
it would be great if it was done timely, but
Okay.
I think what's important is that we have the report that the law commands.
Now to my questions. I have here another chart right here. This shows DEA show cause orders over the last 9 years. That was as far back as I could get the data. Again, the vertical dotted line on that chart indicates when the Ensuring Patient Access Act passed. Now, I'd like to make 2 quick points. First, the data show that rather than declining show cause orders, actually increased after the act passed by nearly 40%. Second, DEA has issued more show cause orders this year than at any time in the last 9 years. Simply put, the Ensuring Patient Access Act has not caused any sort of slowdown in show cause orders. Now, the Ensuring Patient Access Act provided a definition for imminent danger where one didn't previously exist. Let me ask you, why is it a problem for DEA to have to meet a publicly known, clearly defined standard when issuing an ISO? Isn't it appropriate for individuals and companies to know the standards they're being held to?
Senator, the new legislation, in one manner, doesn't apply to the orders to show cause. It only applies to the immediate suspension orders. As far as the orders to show cause go, that is the corrective action plan where registrants are able to come back and come back to DEA and explain what their remedy is or the changes that they've made to the violations that were disclosed.